afternoon, everybody, and I welcome to another study circle meeting for the Revenue Bar Association. And we have an interesting topic on the tribalization after the MBA 6 judgment. And we look forward for this interesting conversation on how the new judgment will impact the tribalization and the future. I welcome all the members of the Revenue Bar, Honorable Accountant Member Mr. Sri Raghunath, and all the senior members of the Revenue Bar, and all my colleagues and friends of the Revenue Bar Association. And I'll just introduce speaker. It's slightly unusual to introduce your own colleague who we worked together for a couple of years in Mr. Datta's chamber, and we know each other well. And it's been a tradition in Mr. Datta's chamber that everybody who was working there had done some research or some contribution to the development of all the tribunal orders, right from MBA 1 to MBA 6 and Roger Matthew and so on and so forth. So when I was there from 2007 to 2014, I had the opportunity to assist in NTT and then the NCLT, NCLAT tribunals. And thereafter the pattern changed and Rahul was there since 2014, and then he took charge of all the other tribunal orders from 2017, 2019 and 2021 Act, and then now the latest judgment of 2025. And just a few words about Rahul. Rahul is an alumni of National Law School of University of Bangalore, and he had been working with Mr. Datta from 2014 and until 2020, and he has set up his own independent practice since 2020, and he's been assisting Mr. Datta also on the commentary on the Constitution of India, which is set to be published in the next year, 2026. And he's also been contributor in the Companies Act, Ramaya, and he has contributed certain chapters. So we all look forward for his views on the new judgment and what is the aftermath of the MBA 6 judgment. And we are all curious to see how this interplay will come and how the government is going to accept this judgment, and how the government is also going to, whether the government is going to come up with a National Tribunal Commission, which was seen as a kind of an arbiter in the judgment. So a lot of positive affirmation in the judgments, and to what extent the government will implement them, or whether they will come up with a new act or something, which we have to wait and watch. But as of today, we have to see what the 25 judgment is going to impact the tribunals at present. I hope over to Rahul.
Thank you, Sandeep. Honorable Member, Office Bearers of Revenue Bar, my colleagues. It's a pleasure to be here, and especially to talk on a topic which is very close to my heart, tribunalization. And it's more than tribunalization, tribunals and how it has impacted administration of justice in India in the last 4 decades. So we will start with how it all began. It began with the 42nd Amendment to the Constitution of India, wherein Articles 323A, capital A, and 323B were introduced. 323A dealt with administrative tribunals, and 323B dealt with tribunals for other matters. So, interestingly, there was a debate as to what is the competence of the Parliament to start or create new tribunals. So when DRT was set up, Debt Recovery Tribunal, a challenge was made into the Delhi High Court, saying that that subject topic is not either under 323A or 323B. What the Supreme Court held is that 323 and 323B are only enabling provisions. You have to also look into entry 8 of the concurrent list, which deals with administration of justice. Not just stopping there, the Supreme Court also said when it comes to DRT, entry 45 of the union list, which deals with banking, is wide enough to create any tribunal. dealing with any ancillary topics which falls under banking. So the interpretation was very clear. If the union had legislative competence under the union list to legislate on a particular topic, they could create a special tribunal to adjudicate disputes under that particular head. You need not go under 323A and 323B. That was the interpretation given by the Supreme Court. I say this particularly because in all this litigation, Central Administrative Tribunal has been taking a stand in the Supreme Court saying they are a special category tribunal because they are 323A category tribunal. So they should be heard separately. Their case should not be tagged along with ITAT, CSTAT or other tribunal. It does not really make any difference. For CAT, it flowed from 323A. ITAT was already in existence right from 1940s. CSTAT also from 1980s. All tribunals under the Indian Constitution are under the superintendence of high courts, and there is no intra-tribunal hierarchy between tribunals. This is the setup. Now, after the 42nd Amendment, the first case which dealt with the tribunal aspect was Sampath Kumar. So in Sampath Kumar, 1987, what happened is, provisions of the Administrative Tribunals Act 1985, they were challenged. So it came up before a constitution bench. Interesting judgment, because the Supreme Court more or less gave an opinion. It said that, see, there are these provisions of the Act which are problematic. Say, for example, one, with respect to tenure of members, it said that 5 years is too less. 4 years is too less. It should either be 5 years or 7 or more. And there has to be an option for reappointment. That is one. Second, it said that when it comes to appointment of administrative members to the CAT, the decision should be taken by either the Chief Justice or his nominee judge. This was absent in the Administrative Tribunals Act. So they pointed out all these problems in the Administrative Tribunals Act, and they said, listen, these are the problems, you make amendments. You make amendments before 31/3/1987 or 1988. There was a date given, without which, if they don't do the amendment, it will be unconstitutional. So what Mr. Datar heard from people who argued that matter is that it was more or less a consent order. The AG had in fact came and mentioned in the Supreme Court that we will make amendments, but it is not satisfactorily come out in the judgment. So SP Sampath Kumar says these are the problems. With tenure, you need more tenure. When it comes to appointment, it has to be made by the Supreme Court judge, the Chief Justice or his nominee judge. It cannot be by the central government. One another aspect which Sampath Kumar held, which was later overruled in Chandra Kumar and other cases, that Sampath Kumar said you can divest jurisdiction of high courts and give it to the tribunals, because there was a provision excluding Article 226 jurisdiction. The logic of the Supreme Court in Sampath Kumar was, as long as there is a body to take care of your grievance or adjudicate your grievance, it is fine. Therefore, even if you remove 226 judicial review by the High Court, it is absolutely fine. But later on, in Chandra Kumar, 1996-1997 Supreme Court, 7-judge, Supreme Court said, you cannot remove judicial review of the High Court. It said that against a decision of the Administrative Tribunal, there has to be an appeal, a writ petition to the High Court, so that there is a judicial review. So that critical aspect was overlooked by Sampath Kumar, which was later corrected by Chandra Kumar by a 7-judge bench. So in Sampath Kumar, as I mentioned, there's one more aspect in Sampath Kumar which is really important. Sampath Kumar said when you are divesting High Court's jurisdiction and creating tribunal, it should create a permanent bench in all the places where there is a bench of the High Court. That is for the benefit of the litigants. As, say for example, if there are no pendencies, say for example, let's take in bench Bombay High Court's bench or in Madurai bench, if there is no enough case for service related matter, there is absolutely no need for a CAT bench to be set up in Madurai. But by and large, whenever High Court's jurisdiction is taken away, there has to be a permanent bench created in the same locality where the High Court is situated. That is Sampath Kumar. Now, coming to Chandra Kumar, as I mentioned, the most important aspect of Chandra Kumar is affirming the importance of judicial review by the High Court. Article 226 power cannot be taken over or removed by any statute. This is the one-line summary of Chandra Kumar. Coming to the important aspects of tribunalization dealt with by Chandra Kumar, the Supreme Court said by then it was very clear that tribunals were not functioning properly in terms of infrastructure, finance, all those activities. Supreme Court held that all the tribunals should function under the Ministry of Law and Justice and not the parent ministry. So ITAT functions under the Law Ministry and NCLT now is under the Ministry of Corporate Affairs, Ministry of Finance, GST, and all other tribunals. But L. Chandra Kumar said all tribunals, because it deals with administration of justice, dispensation of justice, it should fall under Ministry of Law and Justice because tribunals should not depend on the parent ministry for infrastructural support. So this is separation of powers, separation of executive, separation of judiciary from executive interference. So this is the main conclusion. Other than 226, when it comes to working of tribunals, this is what Chandra Kumar contributed to this contribution. Now, coming to Madras Bar Association series of cases thereafter. So in 2002, there were amendments made to the Companies Act to set up NCLT, NCLAT provisions, and Madras Bar Association's writ petitions before the Madras High Court partly allowed, and then the Union of India went into the Supreme Court. And then in 2010, by a constitution bench, it was unanimously approved constitution of NCLT, but gave several guidelines. First guideline is with respect to tenure again. It said that minimum tenure should be 5 or 7, and there must be an option for reappointment. Because a short tenure is always, people will not apply for a post when it's for a short tenure. And especially what the Supreme Court held is that you will take 1 or 2 years or 3 years to be an expert in that subject. And once you start mastering the subject and deliver judgments, it's time for you to retire. It is not helping anyone. Therefore, it is necessary to have a longer tenure for the better administration of justice. So have either 5 plus 5 or 7 plus 7. In essence, there should be a long tenure. Second point which the Supreme Court held is members of Indian legal service cannot be a judicial member. So there was a design by the central government to include members of Indian legal service as judicial members. So if you look at the qualifications given for judicial members for NCLT and other tribunals, even I think up until I think for GST Appellate Tribunal as well, in 2017, the original section 110, it said that a member of Indian legal service could become a judicial member, but an advocate was not entitled to. A retired High Court judge a district judge, or a member of Indian Legal Service. So this was the design. But thankfully in 2010, the Supreme Court 5-judge bench held that an Indian Legal Service officer cannot be a judicial member of any tribunal. This is not because of any disrespect towards the ILS officer. It is simply because an ILS officer, because of the nature of his work, is not trained to be a judicial officer. That is what the Supreme Court said. Because the approach of an advocate, the judicial approach of an advocate and that of a district judge differ from the kind of work an ILS officer is subjected to in his daily life. This is the only reason. There was no absolute reason for any ego or anything of that sort, but the government took it the other way. So in 2010, after tenure, Supreme Court said ILS members cannot be judicial members, and it also said whenever there is a bench in the tribunal, judicial members should always be in majority. It cannot be 2 technical members and 1 judicial member, or just a technical member. Supreme Court said it has to be either equal, and then if there is a split, it has to go before 2 judicial member and 1 technical member. It cannot be before a 2 technical member or 1 technical member. So this was held in 2010, but again in 2017, in the first version of section 110 of the CGST Act for the GST Appellate Tribunal, if you look at the bench composition, it was it was judicial member, technical member state, technical member center. This was again struck down by the Madras High Court in a writ petition filed by a Revenue Bar Association. So all the points which the Constitution Bench considered earlier have been disregarded, but at the same time the executive have tried to bring it back in all the legislation. So that is with respect to the constitution of bench. And another interesting discussion in the Madras Bar Association judgment of 2010, that's a 5-judge bench on NCLT, there's a beautiful discussion on the difference between court, tribunal, what is a tribunal, what is a court, about good summary, at least 10-15 paragraphs on first principles, what is the difference between a court and a tribunal. Second, more importantly, what the Supreme Court held is that, see, when we say that section so and so dealing with this tribunal is violative of separation of powers or independence of judiciary, these are not very vague concepts, because the argument of the Attorney General was, what are the grounds to invalidate a primary statute? Part 3 violation, fundamental right violation, or violation of any constitutional provision, legislative competence. How can you then invoke a concept like independence of judiciary to invalidate or to declare a particular provision as unconstitutional? This was the first objection raised by the Attorney General in 2010. It was again raised in 2015, 2019, 2021, 22, and 2025, 3 weeks back. Successive Attorneys General. Supreme Court said, look, when we talk about independence of judiciary, we are not talking in abstract. They drew that from Article 14. It flows from right to equality. Why so? Because right to equality is violated if a dispute is adjudicated by a body which is executive centric, or a body which violates proper norms of administration of justice. So the Supreme Court rooted independence of judiciary, separation of powers in Article 14, and said that the Madras Bar Association, in their prayer, they may be asking to declare this provision as unconstitutional because they violate independence of judiciary. In fact, what they are saying is it violates Article 14 and Article 15, which deals with separation of powers. So that this conclusion helped us a lot later on, because This has been the argument of the Union of India, saying you cannot bring in basic structure features to invalidate a normal statute. Principles like independence of judiciary or separation of powers. Even the latest judgment also, in fact, when the petitioners finished their arguments, Attorney General took several adjournments, and then finally, one day before the argument, he filed an application to refer the matter to a constitution bench on this very issue, saying that you cannot invalidate a particular provision, saying that it is violative of an abstract notion. Luckily, that application was dismissed because we cited all these things, and there are other aspects to it. So this is another contribution of R. Gandhi, that is Madras Bar Association, in 2010. After that comes National Tax Tribunal judgment. Again, Madras Bar Association, 2014. I think this was actually the first tribunal case in which I contributed. I just did some random research. Sandeep was working on it, and Surup was working on it. I think Anand Patmanabhan also did some lot of research for that matter. So all of you would remember National Tax Tribunal, the idea was divest powers of the High Court on substantial questions of law and create NTT. The net effect was from ITAT, from CSTAT, there would be an appeal to National Tax Tribunal on substantial questions of law, and from there appeal to the Supreme Court, thereby bypassing the High Court. This was challenged. Supreme Court, there is a majority judgment by Chief Justice Keher, and then there is a concurring, I would say concurring and partly dissenting on the reasons, but by Justice Rohinton Nariman. What Justice Keher, before what the bench held, the reason for the challenge was Mr. Datar and then other petitioners argued substantial questions of law can only be adjudicated by the High Court. This is the scheme under the Constitution. Right from common law everywhere, whenever there is a question of law, especially a substantial question of law that is involved, it has to be interpreted by the High Court. Now, you create a National Tax Tribunal. There will be technical members, judicial members, but again, tenure, selection process, eligibility criteria, all those conditions were challenged. Majority opinion of Chief Justice Keher said that it is absolutely fine to divest power of the High Court as long as the newly created body contains the same protection as High Court judges. On this ground, majority comes to the conclusion that the tribunal, the setup in the tribunal, the NTT Act, do not provide that protection with respect to tenure, appointment, selection. It struck down the whole act. Justice Nariman, in his concurring opinion, he goes one step further. He says, you cannot divest. He says you cannot even divest the power of the High Court when it comes to substantial questions of law. According to him, he interpreted right from Magna Carta, the setup in the judicial process in the Commonwealth countries, how the role of higher courts on judicial review. He says, right from the beginning, it's only the high courts that have been given power and under the Constitution to deal with substantial questions of law. On that ground, he says the entire act is unconstitutional. So, this is the reason why I said that this is partly dissenting on the reasons, because the majority said you can divest, but the newly created body should also have the same protection as of a High Court judge. This is what the majority said. But in my opinion, the opinion of Justice Nariman is the correct position. You should not divest power of a High Court when it comes to substantial questions of law. So this is what happened in Madras Bar Association 2014 on the National Tax Tribunal Act. Another important aspect of this judgment is Justice Keher, in the majority opinion, he summarizes Sampath Kumar, Chandra Kumar, and then the earlier NCLT judgment. And he says the principles laid down in these judgments are declarations on basic structure of the Constitution. So he takes it to that a higher pedestal and says these are not just a principles for administration of justice. The judgments, the conclusions of these judgments are a declaration on basic structure. Now, in 2014, National Tax Tribunal Act was struck down. Then in 2015, under the Companies Act 2013, again they brought in NCLT without curing the defects that were pointed out by the earlier Madras Bar Association. Before that, in the NTT Act, there is one more aspect which the petitioners argued, and it's there in the judgment. We prepared a table. It's reproduced exactly. I think we were also asked to share a Word file, if I remember correctly, and then it is reproduced in the judgment. We gave examples from the income tax, even though it's under the income tax, we gave examples where High Court, while interpreting tax cases, go into questions of property law, trust, contract, Hindu law, all these allied law. So we gave all these instances, and then Rohinton Nariman says, see, these are substantial questions of law which the tribunal should never go into. It should be with the High Court. So those instances, it's a good summary of about 50 to 100 cases easily, were tax cases. While dealing with tax cases, the High Court has also interpreted all these allied laws. Now in 2015, when the new Companies Act 2013 was introduced, they rehashed the whole thing without curing all the defects pointed out by the Supreme Court in the earlier round. Supreme Court again quashed the whole thing. But thankfully what happened is that immediately they amended the Companies Act 2013 to more or less cure the whole thing. In terms of search cum selection committee, the Supreme Court said it should not be executive centric. The power of the casting vote should be with the Chief Justice or his nominee judge, and that number of secretaries should not be more than number of judges present in the search cum selection committee. So thankfully those were considered by accepted by the Parliament, and immediately amendments were made, and thereafter we are seeing NCLT started functioning by 2016 or I think 2016. It's been running since then. Now, after the 2015 judgment, the radical change came in 2017 Finance Act. So through the Finance Act, what they did is, so up until then, all the parent statutes used to contain provisions on the tribunals. Say, Companies Act dealt with NCLT, Income Tax Act had provisions with respect to ITAT, and then Customs Act had provisions on CSTAT and all those things. And then I think Trademarks Act contained provisions on IPAB. So Finance Act 2017 through section 184 said that made amendments to all those parent acts and said that there will be rules to govern selection criteria, appointment process for all the tribunals mentioned in the schedule. So it had about 14 or 15 tribunals in the schedule, and an omnibus amendment was made to all the parent acts. The notable difference was primarily on two aspects. One, tenure, because a flat tenure was given of 3 years for all the members. So ITAT, all of you know, from the beginning it was 62 years. So a person could start from 35 and be in the service till 62. Now after 2017 amendment, the tenure all of a sudden became 3 years. Then again same problem with the search cum selection committee. there was no casting vote for the Supreme Court judge, and it was the number of secretaries exceeded number of judicial members in the search cum selection committee. So immediately, I think yes, Revenue Bar again filed a writ petition in the Supreme Court. There were a bunch of other writ petitions also in 2017. All of them were tagged along. And finally in 2020, in Roger Matthew, it all got clubbed together, and in Roger Matthew 5-judge bench, the validity was heard. So we argued two things. One, on the validity of the 2017 tribunal rules. Second, we also said on money bill aspect, because Finance Act being a money bill, we said that you cannot amend all the parent acts by way of a money bill. So on that aspect, the matter has been referred to a larger 7-judge bench. But on the second issue of validity of 2017 rules, Supreme Court struck down the whole 2017 rules, again reiterating the principles laid down in the earlier Madras Bar Association series. With respect to search cum selection committee, there has to be parity. With respect to tenure, again reiterated the same thing. It cannot be 3 years. It has to be either 5 plus 5 or a longer tenure. And protection with respect to tenure, and then on leave sanctioning authority and all sort of other heads. I think this judgment came in 2019 June, the Roger Matthew, and in 2020 January, they came up with another set of rules, making cosmetic changes, but reiterating the same thing. Here, now they increased from 3 years, the tenure was increased to 4 years. Search cum selection committee again remained the same. And Madras Bar Association once again filed a challenge in the Supreme Court. Supreme Court allowed the writ petition. So this was during the COVID. So we used to send scan copies of all the affidavits to the AOR in Delhi. And thankfully, Justice Nageshwar Rao, he took up the matter. I think in January, the rules were notified. Within 3 or 4 months, he finally heard the matter, and the judgment was also delivered. He struck down the entire he did not strike down the 2020 rules. He again pointed out the problems with respect to each rules, with respect to tenure, with respect to search cum selection committee. And primarily, the most interesting aspect of this judgment is that Justice Nageshwar Rao gave a flat house rent allowance of 1.25 lakh to members and 1.5 lakh to the president. So this is something which when the argument was going on, we got many representations. Mr. Datar got several calls from from pretty much all the members. The problem was they get appointed, they will be sent to a city, and then their housing, and they have to find a house, and the rent used to be reimbursed later. Apparently that was the procedure. So the members said we have to fill in a reimbursement form, send it to the department, and then they used to get reimbursed later. When this was pointed out to Justice Nageshwar Rao, through the judicial order, he said no, there will not be any business of any reimbursement. 1.25 lakh separate, standalone as house rent allowance, it should be paid to the members. Thankfully, at that particular point of time, the then AG KK Venugopal, he accepted it. He said nothing, they will not amend it, or they will follow that scrupulously. And I believe that is being followed even now. That's what it's not. Again, then this will have to be highlighted again. Because we were under the impression that this has been followed now. So, but at least now there is a flat rate. So earlier it used to be, I think, Group A level officers reimbursement or something of that sort. So that used to be the metric. Now that is changed. So when Justice Nageshwar Rao, again doing something like what happened in Sampath Kumar, pointed out the deficiencies in the 2020 rules and directed the Union of India to make amendments and come up with new rules. Instead of making new rules, the Union came up with an ordinance again bypassing all the directions given earlier. I'm audible, right? Now the tenure remained 4. Search cum selection committee was fine. But one interesting aspect was that the search cum selection committee had to recommend 2 names per vacancy. We couldn't understand what was the logic behind it. So we have a search cum selection committee headed by a Supreme Court judge with representation from the ministry. So there is the Ministry of Finance Secretary and then the Parent Secretary. And then there is President of the Tribunal and then a nominee judge of the from the Supreme Court. So 2 plus 2, 4, and casting vote to the Supreme Court judge. So when there is representation from the executive, what is the need for search cum selection committee to select 2 names per vacancy? Central government came up with an interpretation. They said, after the names are recommended, IB reports are called and we get feedback. And based on that, the Appointments Committee of the Cabinet, ACC, will take a final call and make the appointment. Again, several applications were filed. Justice Chandrachud called for records of ITAT appointments, the original files. Interestingly, in a recorded judgment, Justice Chandrachud records that the files see names of the people who, selected by the Search cum Selection Committee. Now there is a column which says feedback / remarks. It was completely unheard of. Nobody knew what this feedback was. Justice Chandrachud then records that any input to be given by the Intelligence Bureau or by the Income Tax Department, whether that particular applicant has a penalty against him or moral turpitude or whatever it is, all the feedback should be given to the Search cum Selection Committee before it makes the recommendation. And struck down the provision which said Search cum Selection Committee has to recommend 2 names per vacancy. Therefore, Tribunal Reforms Act, with respect to tenure, on this aspect of 2 members per vacancy, was struck down. The entire ordinance was struck down. Within 28 days, they replaced the ordinance with the Tribunal Reforms Act in 2021. Immediately, we filed one more writ petition, which unfortunately got footballed for the last 3-4 years, and finally it was heard last month. And we gave a chart. Tribunal, the ordinance earlier, the earlier ordinance, clause by clause, identically replaced by the Tribunal Reforms Act. So, admission stage, we argued, Mr. Dhatar argued, my lord, I will not take more than 2 minutes. Please see the table. Identical provisions have been struck down. Please follow the same judgment. I don't have anything else to argue. This is what he mentioned during the admission hearing. But notice was issued and then it got delayed for about 3-4 years. Now, thankfully, Justice Gawai, in his latest judgment, he records that how this is identical to the earlier tribunal ordinance and reiterates the same principles once again. Now, during the argument, again, this particular aspect of Intelligence Bureau report and all those things were brought up. To justify, I believe, one section of a Search cum Selection Committee's appointment for ITAT, there were about 42-43 members shortlisted by the committee, and out of that only 23 or 24 were appointed, and others were not appointed at all. And then that list was discarded, and fresh applications were called. So there are many individual applications pending even now, even though there is a judgment under the Tribunal Reforms Act, and those applications will be heard most likely in next couple of months with respect to the Tribunal Reforms Act. Now, coming to the aspect of what happens, what is our future. Before that, the role of Revenue Bar Association with respect to GST appellate tribunals. So I will make a few submissions on this, and then we can see on what is the future of tribunalization. So Revenue Bar Association, we filed a writ petition in 2017, immediately when the GST provisions came into force. It was very problematic for two reasons. One, like I mentioned, the composition of the bench. Judicial member, technical member state, technical member center. That is, we argued that it cannot happen. It has to be either two judicial member and one technical member, or one judicial member and one technical member. Technical members cannot, because technical members, the argument was that from the side of government, their argument was that they have experience, practical knowledge, and they represent both the state tax and the central tax, so they should be part of the bench. This was actually what the ASG argued in the court when we challenged it. So in 2019, the writ was taken up. So this was the first problematic aspect of GST provisions. Second was, advocates were not even eligible to become a judicial member. Only a retired High Court judge, or a district judge, or a member of Indian Legal Service. So we argued that advocates should at least be made eligible to apply for the post of judicial member. So the matter was heard by Justice Manikumar and Justice Subramaniam Prasad. They gave a very good judgment on the first aspect. On the Indian Legal Service, they said they cannot become a judicial member. On the second aspect, on the bench composition, categorical finding, it has to be equal, judicial member and technical member. It cannot be technical member and judicial member. But on the aspect of advocates' right to apply for a judicial member, High Court said there is no inherent right on advocates to apply. But they hope that the Parliament would make suitable amendments and then make them at least eligible to apply. So we filed an appeal to the Supreme Court SLP. That SLP is actually still pending, even date. But later on, that section 109 and 110 was substituted, and the new provisions were also challenged. That is again pending in the Supreme Court. So in the new provisions of sections 109 and 110 of the GST Act, which should ideally follow the recent judgment of Justice Gawai, the two problematic provisions are again, one, per vacancy, two names should be recommended. Second is qualification of advocates. So on one hand, the provision 110 says an advocate with 10 years of experience is eligible to apply for the post of judicial member. Then there is a proviso says minimum age is 50. So indirectly, they revoked or legislatively overruled all the previous decisions. So till now, what the Supreme Court said is that advocates should be eligible to be made eligible to apply for the post of judicial member. Advocates with 10 years of experience. That's what the Supreme Court said. Now they said okay, advocates with 10 years, but indirectly said they have to be minimum 50 years. So the rationale of Supreme Court when they said 10 years of experience is under Article 233. An advocate with 7 years of experience can become a district judge. Then there is no rationale for you to keep 50 years as the minimum eligibility criteria to become a tribunal member. That was the logic. And second, Justice Ravindra Bhatt in the, I think, MBA for 2022 Madras Bar Association judgment gives a very beautiful reasoning as to how, say, for example, if a particular advocate is becoming a judicial member at the age of 35, it is a full service for him up until 62. And going by the progression, he can then be considered for elevation to the High Court as well. More than that, the pool of selection will be bigger, will be wider. Right now, we are getting members, the people who are applying, say, for a particular judicial member post, if it's 50. Now, if you make it 35 or an advocate with 10 years of experience, you will get more number of advocates who are willing to apply for that particular post. So, the important aspect is eligibility and suitability. The Act can say an advocate with 10 years of experience is eligible to apply. But suitability will be tested by the search cum selection committee through interview, analyzing that particular candidate's technical experience or knowledge. So what we argued is, it is not necessary that all advocates with 10 years of experience are going to be automatically appointed. There will be a suitability criteria evolved by the search cum selection committee. They will interview, they will apply their mind, they will appoint the advocates who are experts in that field and who have made a decision to apply for the post of judicial member for a longer tenure up until 62 or 65, whatever that case may be. Now, that is indirectly circumvented again in the GST provision, section 110. Now, we are trying to get that matter also disposed of as early as possible. But whatever the outcome is, the appointment of the members, I think about 90 members have already been appointed for GST Appellate Tribunal. That will not be affected in any way, but at least for future operations, our endeavor is to at least reduce the eligibility from age of 50. Advocate with 10 years or 15 years of age should be made eligible to at least apply for the post of judicial member. So this writ petition is still pending. So in terms of GST Appellate Tribunal, Revenue Bar writ petitions in the Madras High Court, which that judgment was accepted by the Union of India, but again provisions were substituted later. That's the only aspect. Now, what next? After this judgment, after 6 or 7 rounds of judgments. So we had problems from 2017 to 2020, Roger Matthew, many appointments were made under the 2017 rules. So in Roger Matthew, when the Supreme Court struck down 2017 rules, it said that all the appointments made up until 2020 will be governed under the Parent Act. So that has been continuing. So in the Parent Act, their tenure was up until 62 years or 65 years, whatever that was. Now, the new judgment says they have struck down the provisions of the Tribunal Reforms Act, and all the appointments will be based on what was held in MBA 4 and 5. So that is 5 years plus an option for reappointment, and or 62, whichever is earlier. Now, I believe there is a lot of confusion with respect to what is going to happen to members who got appointed between 2021 and 2025 under the Tribunal Reforms Act. So the specific appointments were made under Tribunal Reforms Act. Now that provision is gone. What will happen to their tenure? There is some uncertainty on it. Now, my interpretation is 5 years or 62, but necessarily all those members must file a miscellaneous application to the Supreme Court for clarification. That is the only way out. Because without a definitive judicial pronouncement, it is going to create unnecessary confusion again. Either they will have to write to the parent ministry on clarification as to what is the situation now after the judgment, immediately individual capacity, or through the association, miscellaneous application should be filed in this disposed of matter for clarification with respect to the tenure of members appointed from 2021 to the date of judgment. That is with respect to the tenure of members who have been appointed in this tenure. Now, what next for tribunalization? So repeatedly in Chandrakumar, 7-judge bench held that all the tribunals should be under Ministry of Law and Justice for infrastructural support, financial support, or any support for that matter. I read in newspaper, I think earlier this year in January, February, NCLT Bombay, the employees, the staff of NCLT Bombay, they went on a strike for non-payment of salary. So the registrar put out a circular saying it is not our fault. We have requisition from the Ministry of Corporate Affairs. Payment is yet to come. So situations like this should not happen. Therefore, in Roger Matthew and even now, the Supreme Court has held there has to be a National Tribunal Commission. There has to be a separate body dealing with appointment, tenure, selection, infrastructure support, budgetary support. And these tribunals should not depend on the parent ministries. In Roger Matthew, that was a mandamus to the Supreme Court, to the Union, to set up a NTC within 6 months. That has not happened. Even now, I think there is the mandamus is on 3 months. 3 months. Let us see if they do something. But from my personal experience, they will come up with one more enactment in the winter session, which will be identical to the earlier provisions. Hopefully not. So, but it is high time we treat tribunals as a separate branch for administration of justice. It has to be streamlined right from appointment process to the retirement benefits or all sort of budgetary support. It has to be through a National Tribunal Commission. In fact, we also gave a recommendation to the Supreme Court saying right now the precious judicial time of the judges are being wasted by sorting out all the applications, sitting through appointment process, interviews, picking out names for tribunal members. You have a separate body that is headed by a retired Supreme Court Chief Justice or a retired judge nominated by the present sitting Chief Justice. Let them handle the appointment process. That is also another option to save time, because right now there are about 10 to 12 major tribunals, and one or the other Supreme Court judges are always part of appointment process, going through applications and conducting interviews. So it would be a great step in future if Union takes this suggestion and creates a National Tribunal Commission and treat this as a separate body for administration of justice than by treating it as just as a department under any other ministry. So this is the overall aspect of what transpired from Sampath Kumar to the latest judgment and the implications of the new judgment. Let us hope for the best. Let us see if NTC becomes reality. So any questions on this? Yeah.
So you said the law settled on the issue as was a substantial question of what to be decided by the High Court. Then what is the legality of the NCLATs which are functioning around the country?
No.
Appeal then goes to Supreme Court.
No. What NTT judgment said is, the majority judgment said is, you can divest the High Court of the power to deal with substantial question of law, but the body which is created newly to deal with that question should be of the same stature as that of a High Court. So NCLAT, you will see it's headed by a retired Supreme Court judge, and it's always a judicial member and a technical member. Their tenure is protected, but technically we can still challenge it. But unfortunately what happened is that's actually a good question. What happened? In 2015, when this NCLT and NCLAT challenge was taken up, that was all of a sudden without a notice, they constituted the Constitution bench, and the bench was in a hurry to finish the matter within a day. So quite a lot of provisions were not even argued, the validity. If you look at the Companies Act, I think section 415 or something, that has a 50-year age limit. So even though that was challenged, there is no discussion in the judgment, nor the Mr. Datar also could not argue on all these aspects. So the Supreme Court finally gave its stamp of approval by seeing that, okay, there's a retired High Court, a Supreme Court judge who is going to be manning the appellate tribunal to deal with substantial questions of law. So the only condition is that at least there should be some protection. But in National Tax Tribunal, that was not the case. That is the difference.
Just one clarification. In terms of members appointed in 2024, under the new 21 Act, which is now struck now, you said you can file a miscellaneous application for clarity.
Yes.
But otherwise, just to interpret what it is right now, assume 21 goes away. The earlier, it reverts to the earlier one, which is 5 years, and then a reappointment
Yes.
possibility.
Yes, there is a possibility. No, not a possibility. The Supreme Court says necessarily there has to be an option for reappointment.
Oh, I see.
Yes.
It's an option for reappointment.
It is an option for reappointment. But again, the problem is, what is the modality for that reappointment? What is the process? So what we argued even now is that, see, it cannot be a situation where the tenure is 4 years and then the member has to again apply at the end of 4 years. Or say, for example, you're going to be, your tenure is ending on such and such date. Unless new applications are called for, the member cannot apply. So if in that member's 4th year no new applications are called for, there is no option for him to apply.
So in this case,
And the rule also specifically says the member has to apply. So it's again a selection process. So, but the only caveat is that the experience will be given a consideration at the time of reappointment. That is only saving grace.
I think a miscellaneous application is best to get a...
Yes. Yes.
No, but the term is extended to 5 years.
Yes.
But that has to be communicated
That
by the ministry.
it's better to write to the ministry for clarification.
I think 2021 appointments independently decided.
Yes.
Only the 23 and 24 appointments are at the gray.
Yes.
21 appointments, they said it is up to the age of 62 years.
Yes.
It is the Parent Act.
Is the Parent Act.
Only subsequent 21 appointments.
It will be as per the earlier decisions of the Madras Bar, which is 5 years.
MBA 4 and
MBA
5.
4 and 5. Yes.
4 and 5.
Which is
Accordingly, it is 5 years.
yes.
And eligible for reappointment. And priority will be given in reappointment.
Correct. Correct.
These
These are the things.
But the age limit will be 67.
It will be 62
62 only, not 67.
because that was the law back then. 67 was increased here. So in the Tribunal Reforms Act, they increased it from 62 to 65.
But that is not there in MBA 4 and
Yes.
5.
That
MBA 4 and 5
yes.
was sought for only 62.
No, honestly speaking, this was not argued this time. The chief should not have included that particular paragraph. He wanted to protect the members, but at the same time, unfortunately, has created new confusion. Because the bench made it very clear that individual applications are not being heard, only on the validity. When that is the case, ideally, that one paragraph now has created more confusion.
Okay, now for the 21 batch also, those who are appointed, they retire by next month for first
They have to-
week,
yeah.
third week or so. They will be ending their 4 years term. For them, they have to be given now. Either ministry has to say that.
Or they have to immediately file an MA.
Though judgment is there, judgment cannot give them an extension. It has to be through an.
Definitely, that is actually the biggest problem.
Intimation by the ministry at least.
Yes, yes.
That has to be intimated.
So
that you have been appointed after the age of 62.
Yes. So the safest option, as I see, there are many members who file applications in their individual names. There is absolutely nothing wrong with that. If there is any confusion with respect to tenure, necessarily file a miscellaneous application for clarification.
At least for them it is immediate.
Yes.
The next 21 days they have to report.
They have to file. They have to file, mention it, bring it up at the earliest.
Or the ministry should give it.
They will not do anything.
Instant and back into this. Two questions from people who are watching online. One is Armed Forces Tribunal. even that tribunal does not appoint advocates as the judicial member. So in that sense, whether, to that extent, whether that tribunal is also violating the terms of RBI judgment of the Madras High Court, though also its direction, or it's violative of Article 14.
See, there is a challenge pending on Armed Forces Tribunal in the Supreme Court. The argument is, see, army is it's a separate creature altogether. Only right now the members, the judicial members are from the service, retired people or so. Unless you have some experience with the working of army, it may not be conducive to become a judicial member for an advocate. But at the same time, I don't see a problem. Say, for example, if you are exclusively appearing in AFT, I don't see a reason why he should not be made eligible to be a judicial member, because he will be an expert on that subject. So that is definitely pending. Now, what one more aspect I heard is with respect to the, I think, what I don't remember the name, with the judicial member, there is a not technical member, there is another administrative member or someone in the AFT. So they are appointing people from defense accounts services also to the tribunal who have absolutely no experience when it comes to administration of justice. So that is also pending. But for if you're asking for my personal opinion, I don't see for an advocate who's exclusively appearing in AFT. There are, especially AFT, Chandigarh, Delhi, there are quite a few advocates who handle only these matters. They know the subject. I don't see a reason why they should not be a judicial member in tribunals, AFT tribunals.
Another question is there. CAT and NCLAT, the retired judges are appointed. Now, in view and appointed under the respective parent act, constitution and the Companies Act, whether this judgment of the, which is quashing the Tribunal Reforms Act, will have any impact on these two tribunals?
Only on the tenure aspect. Only on the tenure.
Or can one say a view that it should be equated with the High Court judges because who are retired judges of who are appointed as NCLAT members, they are already 62 and completed, and they have been appointed up to the age of 67. Then the question arises, because of the Tribunal Reforms Act being quashed, whether what will be their tenure? Because post 62 they come in.
After 62, you're talking about only the retired judges.
Retired judges, because they are judicial members. There might be a chairperson also, president also, even a judicial member also is a member in the NCLAT. Retired judges of High Court can also be a judicial member.
See, for a
Just
not
to
a-
add,
Huh.
just to add is that even in 1980, the retired commissioners are appointed in post 2021. They are already 62. If you say that term is age at 62, post 2021 batches, they are already more than 62. Assuming at the age of 61 they are appointed, it's 2 years old. They are already 63. What happens to that?
Yes.
no, so in the see, all these judgments, the focus has always been on the members, always, not on the presidents or.
But they are members. If we difference what sir said also, retired High Court judges can become judicial member of NCLAT.
Yes, yes.
Now he is a judicial member. He is not the president of the tribunal or neither the vice president. He is just merely a judicial member in that sense. Now in that sense, he is on par with any other judicial member who would have come from bar also.
Yes.
So in that sense, there cannot be a disparity on tenure of these two judicial members per se. So an advocate who would have joined, he will get a 62, assuming he joined young or late, whichever, he will still have 62, but a retired judge post 62 still enjoys a tenure of 67. So in that sense, there is a discrimination. Whether this has been addressed, not addressed.
No, it is
or
not
how to be
addressed. It is not addressed.
Not. Then the question is what follows there.
No, I think for retired judges who become members, it has to be a flat tenure, 4 years or 5 years. Let it be 5 years. And obviously there cannot be a reappointment. 67. So whichever is earlier. So if you get appointed in 64, you get to serve for 3 years.
The same yardstick should apply for anyone member who was appointed either from the bar or from judicial service.
Who's more than 62? Yes.
In that sense, then the judgment of Supreme Court saying that follow MBA 4 and 5 gets diluted.
I believe this will be a very minority of cases, but necessarily this requires clarification. I don't know there will be how many members would be there in that bracket, 63, 64.
No, most of the commissioners.
63, 64.
Most
Of the commissioners.
What will happen is you'll have a bunch of people 62, you'll have a bunch of people who have 65.
When they would have retired at 60, then they would have got appointment in 61.
In fact, in our batch, 2024 March appointed, out of 22 members, 16 were commissioners, only 6 chartered accountants.
Okay, okay.
All the 16 are, I think they have crossed 62, I'm sure.
Maybe I think then this is a good opportunity for the association also to file a MA, because Advocates Association Bangalore, they have been filing applications, contempt also, in terms of appointment to ITAT.
But most of them were reading that the tenure appointment of 5 years is applicable to 67 years. That is what most of them were interpreting.
So we can interpret, but the problem is unless the ministry gives a proper instruction on writing,
62 is applicable to the people who have been given an employment up to the age of 62. But for those who are coming on a tenure appointment, they will be eligible for up to the age of 67. That is what hence they were, in fact, last week they made a transfers also, including 21 batch and 24 batch. That means to say that they are there.
no, we will see. I mean, from my personal experience, I am 100% sure that there will be an amendment in the winter session.
21 batch have been posted here, 2 members.
Okay.
And 24 batch have been posted to Delhi and Mumbai and all. So that means both of them are there. Though they are more than 62, number one. Though their term is going to end in December 21st of December 2025. They will end it. They have been transferred here. A week or so they'll join. That means to say that they are in the service.
But I am sure in next 3 weeks we will have clarity. There will be an amendment. There will be a clause saying, notwithstanding anything contained in any judgment, order, decree, this will be the status of the members appointed. So that is what I believe. I mean, from my experience, I feel that is going to happen. We will get clarity in the next 3 weeks. So thank you, everyone. Thank you, RBA, for inviting me. It's been a pleasure to address the group. Thank you, sir. Thank you, Sandeep.
Thank you, Rahul. Thank you for taking us through the journey of Sampath Kumar to the MBA 6 and a lot of interesting aspects in terms of independence of judiciary, separation of power, and the role of as chambers from the chambers of Mr. Datar as to how actively and persuasively we have been protecting the tribunals as such, securing the independence of judiciary. And in one sense, we are proud and we are happy that this successfully we have been, I think from Mr. Datar, I think for last 29 years, he has been involved in one matter or the other, right from 2007, if I'm not wrong. And successfully, one way or the other, we have been involved in reformation of tribunals. And thank you, Rahul, once again for enlightening us with all the aspects of tribunals, appointments, and the tenure thereafter, and also the clarifications with respect to the latest judgments and what is in store and what we can expect from the government also. Thank you, and I thank once again honorable member who's here, accountant member Mr. Sri Raghunath, and all the senior members of the Revenue Bar, and thank the EC committee to have this organized, and all the colleagues at the bar for joining us. And we have a high tea now, so we can all join us for the high tea, please. Thank you.
It is an harmonious interpretation of good people. Then for and for appointment related or employment related, it will be 67.